This is Scott Henson with the blog Grits for Breakfast. On June 23, 2016, I sat down with Derek Cohen, Deputy Director of the Texas Public Policy Foundation Center for Effective Justice, to discuss his just published public policy brief titled Texas Mandatory Sentencing Enhancements. Here are some excerpts from our conversation.
Well, to get to the why sentence enhancements, you need to understand why we punish to begin with. There are generally five points of philosophy on that. There is retributivism, there is deterrence, there is incapacitation, there is rehabilitation, and then there's restoration. Obviously, deterrence being the operational goal here for sentence enhancement. In other words, if you have a person who has who committed an offense, but has also checked some other boxes that make that offense either more heinous or have done more than one offense, this is what's used to enhance the actual sentence. Beyond that is if it were just the instant offense in a vacuum. So the philosophy of it is simply this will stop future offending, both specifically for the individual by increasing the amount of punishment that they receive, and for others in a general deterrence as well. So in other words, other people see this person being punished, and they're going to say, I don't want any of that, so therefore I'm not going to commit that act. Well, if you look at the total of the body of scholarship that exists on this subject, generally, no. It works on certain types of offenses in certain isolated incidents. It also shows that those same offenses in other instances increase. So it's one of those things where it's half one, 6 dozen of the other. Therefore, there really is no causal inference you can actually draw from that, simply because we have not isolated one particular corpus of sentencing enhancements that get that deterrent result that can actually be used to suppress crime and increase public safety. What does a conservative philosophy on enhancements look like? And to be honest with you, a conservative philosophy on enhancements would be if that deterrence rationale were demonstrated. In other words, if we shown that the more these enhancements were applied, that crime would go down independent of the prevailing trend, and we do have the statistical ability to do this. This is something that can be done relatively simply. Then we could say that this is shown to be positive, beneficial to public safety, so therefore we should probably proliferate it. The only problem is that judicially these enhancements are binding. They actually tie the hands of the judiciary. They divest them of some of the discretion that we give them. And so by allowing the legislature to do the job of the judiciary, which is essentially what happens in this, we are actually cutting the judges out of the one role that they should be doing. They should be calling balls and strikes and pronouncing sentences within the range that they're given, and not necessarily being hamstrung by some hypothetical situation that might not look like the situation we see in reality. I think that's a very good example insofar as it applies to the clinical judgment of humans in the criminal justice system in general. So the Wendell-Callahan case specifically, now that's a federal case, and as we know, the federal government has got rid of parole a long time ago for various political reasons. So Callahan, who was not a safe public safety risk by anyone's assessment other than two of the prosecutors, this gentleman had been arrested for the most recent offense. His instant offense was a lower level drug crime, but his record had a non-fatal shooting, several instances of domestic violence against his soon-to-be victim, and several other events, basically things that are dispositive of him not being a credible public safety risk for release. So he was up for review. They reviewed it. They took a look, and they said, he seems like he's not that much of a risk. We'll let him out, despite this demonstrable past. And then 18 months after his release, he killed his ex-girlfriend and her 2 children. And this is being upheld as that this is why we need tougher sanctions. This is why we shouldn't have release at all. Not to mention that he was a red line release as opposed to any sort of monitored release. And it tends to actually show that when we look at the horse sense diagnosis of crime, saying this person looks like a risk, this person doesn't, we're not that good at it. Now, actuarially, we're getting pretty good at it. We have pretrial instruments, we have post incarceration supervision instruments, things that actually help triage those resources to their best use. Now, when it comes to that particular event, there was nothing that they could have done to prevent that outside of post-release monitoring. But this is where enhancements. This is a case of enhancements missing the boat entirely, because if the enhancements only apply to the instant offense and don't take into account, one's predilection of violence as demonstrated by criminal record previously, there really is no way to make sure that we are applying these statutory instruments to the people that hypothetically, when they're passed, we're thinking of. When this is one of the points I like to make about sentence enhancements is, there's this, they fit this hypothetical offender in our minds, in the minds of the legislature, in the minds of the public. And what we see in reality is that hypothetical offender never looks exactly like, never looks like as we envision it. In the offense itself, there's going to be mitigating factors that probably would suggest a lower sentence would be important. And then for Mr. Callahan, there would be aggravating factors that would not factor into the calculation of the enhancement. So that's just proof positive that we really aren't good at punishing through statutory influence like enhancements, and why judges should be invested with the discretion to be able to to give appropriate sentences, be it on the low side if someone's not a public safety risk, or on the high side if they are. Conservatives don't like gun crime. I mean, yes, we enjoy guns and access to guns and our civil rights to keep and bear arms, but if you abuse that right and use a gun in the furtherance of criminal activity, those rights tend to be forfeit. Now the problem is that we try to again take this hypothetical context and use that to punish these offenders that have not necessarily blinked into existence yet. So taking that perspective, federally, there was the case of Weldon Angelos, and that's a lot of individuals in the criminal justice reform movement are very familiar with the case. He was actually charged with his crime, which was drug dealing, which is a crime. His crime of drug dealing was enhanced with a firearm that, when he was arrested, was not even on his person. He had a legally owned firearm back at his place. Things like that show that there is if we believe that criminals should not have firearms, that's a completely separate argument, though. There is no forward-looking rationalization. We can't predict future crime quite yet, despite Minority Report. But if that's something, that's a different argument. Then should we actually have a construct in place whereby we can punish somebody for a firearm that they own legally and don't even use in the furtherance of criminal activity? And so I think firearm enhancements are an easy policy matter, simply because nobody wants firearms to be used in criminal activity, especially as you and me as part of the general public could be on the other end of that firearm. But that's not necessarily how they work out in sentencing enhancements. Now, the use of a gun in and this is similar to, I know Ohio statutes reflect this, that the instrumentality of the firearm itself, how it's used, and it's tiered, that actually enhances value there 1 to 6 years, again, depending on the actual usage. But that's more of a scalpel approach. Now, sadly, in some of the research that I've done prior to even moving to Texas, I didn't find much deterrent effect even when detrending the general crime drop that we had in the United States. You don't necessarily see that be getting a better public safety result either. But again, at least that's more tailored than this blanket enhancement. So you also mentioned drug-free zones
right.
in school enhancements. That's probably one of the worst manifestations of sentence enhancement. And I have to qualify. This isn't because, dealing drugs around the school is not bad. Quite the opposite. The idea is that we have this sentence that's computed by geography. And that geography is so ham-fisted. Was it 1,000 feet from a school? Well, 1,000 feet from a school to turn that into a violent offense, first of all, that doesn't necessarily need to be on the school property. That doesn't even need to be on the same block as the school. It's just simply that is the proximity. And the school itself doesn't even need to be in session or even open generally. So using an arbitrary geographic designation as enhancement for a sentence really doesn't make sense for any of the 5 goals.